Do you all swear or affirm that the testimony you give will be the truth and the whole truth?
Yes, ma'am.
Yes, Your Honor.
All right. I have a question. So I know that Attorney Weinman is look like at a kid's doctor's appointment. So counsel, she's going to be your first witness?
Yes, I was planning just 3 minutes for with my Wayman.
Okay, that's what I was going to ask, if it would be okay if I didn't know if you were going I was talking out of turn, if she could go first so she can get to the appointment. Okay, so prior to going on the record, we had stipulations of some exhibits that were pre-admitted. They will be admitted at this time. So mother's exhibits 1 through 8 are admitted. Father's exhibits 1 through 3 and 5 through 13 are admitted.
Correct, Your Honor.
Okay.
Thank you, Your Honor.
You're welcome. And we are set here today. The single issue before the court is possession and access. You all are set at 15 minutes aside. That will include any opening and closing statements, should you all choose to make one, as well as any examination. Counsel, would you like to make an opening statement at this time?
Yes, Your Honor, just briefly, this is modification of a 2017 order out of Tarrant County. We filed modification and the case was transferred because the father moved. Now, evidence will show that my client has been in recovery now and sober for 6 years. And also, the evidence will show that she has demonstrated total behavior change. She completed counseling, probation, turned her life around, and simply wants to be involved in children's life. With help of this court, in 2024, she was awarded supervised visitation electronically in person. There were some roadblocks, but she, by agreement from the parties, she's been able to exercise supervised electronic visits with the children since December of 2025. In some, mother just requests the court that she will be would be allowed to continue to have graduated access to and possession to the children. Thank you, Honor.
Thank you, counsel. Counsel, would you like to make an opening statement as well?
Briefly, Your Honor.
Okay, go ahead.
In 2017, a default was taken against mom. She had left the state for Florida due to drug use at that time. My client, father, was awarded sole managing conservatorship. Mother had no possession and access at that time. It wasn't until she had been absent from the kids for 8 years that she filed her modification to try to get back into the children's lives. Meanwhile, father and the children have moved on with their lives. They've had to deal with the abandonment of mom with regard to these kids. The kids have been in counseling. Dad has had to help them work through it. And that has brought up a lot of these same feelings with her coming back into the children's lives. In addition, mom, even though she had the opportunity and in fact told the kids she would be seeing them March 15th, no-showed and did not give the kids any heads up that she would not be attending, again, creating this sense of abandonment. Father believes it's in the best interest of the kids that no possession and access continue moving forward unless it's by agreement of the parties. These children are younger, so we're not conditioning it on the children.
Thank you, counsel. You may call your first witness.
You know, I would like to call Wendy Weinman, please.
Go ahead.
Ma'am, could you state your name for the record?
Wendy Weinman.
And you were appointed to supervise my client's electronic visitation and in-person visitation into 2024, correct?
Yes, ma'am.
And during the year of 2025, my client didn't have electronic possession. And could you tell the court what was the issue there?
There was some issue. I don't know all the details. I just know there were some issues with the order and dad not cooperating, but I don't know the reason behind it or all those details.
So since December 2025, you've been supervising electronic access by my client and to the children on Sundays, Mondays, and Wednesdays for 1 hour each day, correct?
Correct. Those are the new days that we're doing, yes.
Right. And in some, you have observed the parties, meaning my client and the children, for now 39 times, correct?
Approximately, yes, ma'am.
Now, could you tell the court, is my client engaged with the children during those visits?
She is.
And do the children enjoy the visits? And could you briefly describe those visits with my client?
They seem to enjoy them and interact with mom. Often they're distracted because they're outside playing or they're at a park or skate park or several times driving with dad in a truck. There is some distraction. Dad's talking to people around them or playing music in the background, and it makes it hard to hear. So the kids are distracted. But overall, the visits with mom are going well.
At this time, do you believe that, do you have any concerns about mom having unsupervised electronic access to the children?
I do not.
I pass the witness, Your Honor.
Okay, Cross.
Ma'am, you have not seen Miss Jackman with these kids in a supervised setting, have you?
Not in person, no.
So it's premature to say you have no concerns of unsupervised access, correct?
She said electronic access.
I misheard that then. Thank you. In terms of these visitations that are electronic, a number of them have been late or have been missed, correct?
I believe there's been 2 missed and a couple late, but that's been on my part due to other
Objection,
visits
non-responsive.
I've had.
Sustain.
Okay. Pass this witness, Your Honor.
All right, is there anything further for this witness?
Yes, Your Honor, just 2 questions. You
Go ahead.
also were appointed by Judge Lee to supervise in-person visitation, correct?
Correct.
And they were to take place after 20 electronic visits on part of mom, correct?
Correct.
And you and my client are ready to have in-person visitation, supervised visitation with the kids, correct?
Yes.
Do you have any concerns with my client having in-person and with you visits with the children?
As long as it's supervised by me right now, no.
I pass the witness.
Thank you. Anything further?
All right, guys, this case kicks off with a calm but loaded courtroom atmosphere, where even a simple scheduling issue hints at underlying tension. As the judge lays down the structure, you can already sense that this isn't just routine. There's a deeper conflict brewing around parental rights. The focus on possession and access immediately raises the stakes, making it clear that this is about control, connection, and the future of these children. From the very beginning, both sides know this is going to be a tight and emotional battle.
No, Your Honor.
All right. May this witness be excused.
Yes, Your Honor.
Thank you for your time.
Thank you, Judge Lee. I'm sorry about that. I mean, Judge Bailey, I'm sorry.
I was like, is she here?
I'm sorry, Judge. I'm sorry.
No problem. Have a good day.
You too, and bye.
Thank you. Good morning. We'll take care of you. Okay, you may call your next witness.
And I will call my client, Brittany Jackman.
Okay.
You state your name for the record.
Brittany Jackman.
And Brittany, we have our requested relief before this court. Judge, may I have permission to publish?
Yes, you may proceed.
Brittany, I have your requested relief in front of us. And today you're asking this court that you will continue to pay child support as ordered by this court, correct?
Correct.
And it was determined by Judge Lee in 2024, correct?
Correct.
And you have, you're requesting this court that you have unsupervised electronic access to the children, continue that access on Sundays, Mondays, and Wednesdays from 6 to 7, correct?
Correct.
And you also requesting this court that you continue to have supervised access under auspices of Ms. Weinman for the next 6 months, once a month, and subject to 7 days notice to the father, correct?
Correct.
But you also request that you will have unsupervised access pursuant to the standard possession order beginning September 1st, 2026, correct?
Correct.
Your Honor, okay, let me ask you questions now. You and Mr. Tomlin were never married, correct?
Correct.
And you were together for 4 years?
Just about correct.
And you had 2 children, Blaze and Marley, correct?
Correct.
And at the time that you separated, Blaze was 3 and Marley was 18 months, approximately 18 months, correct?
Correct.
Now, in 2016, when you guys separated, you lost your job, correct?
Correct.
You were jailed for fraud and forgery, correct?
Correct.
You went to prison for 6 months, correct?
It was a little over 6 months. My sentence was 15 months.
Okay, and at the same time, the order out of Tarrant County came out on February 8, 2017, that you have no possession and access to the children, correct?
Correct.
And that order was by default. You didn't show up, correct?
Correct.
Now you came out of jail in 2018, correct?
Correct.
And isn't true that you moved to Florida and you remain living in Florida as of today?
Correct.
Now you try to see your children since you got out of jail, correct?
Yes, ma'am. Correct.
Were your efforts successful?
No, they were not.
At one point, you and Mr. Tomlin agreed that you would come and see your children in the year of 2020, correct?
Correct.
And you came to Texas, and did you see the children?
No, ma'am.
And why so?
I had set up a time with Mr. Tomlin, which then he decided that was no longer going to work for him. When he finally did decide to allow me to see the children, I was already in Alabama on my way home.
Okay, and on about that time, 2020, Mr. Tomlin blocked you from his number, correct?
Correct.
Okay, is that we filed this petition to modify on June 20, 2024, correct?
Correct.
And before even we filed the well, let's read back up a little bit. So you after you've been sober now since August 26, 2020, correct?
Correct.
And after you were released from jail, you attended drug counseling, correct?
Correct.
Therapy session, correct?
Correct.
And you were placed for probation for 2 years, and you were subjected to random drug testing and urine testing, correct?
Correct.
And you successfully completed this probation in September 2021. True?
Yes, ma'am.
Now, before even we filed petition, we took you to the drug test, correct?
Correct.
And the drug test was negative, but for marijuana, correct?
Correct.
And may I have permission to publish this time?
Yes.
And Brittany, this is your drug test taking before we filed after we filed, but before the hearing in December of 2024, correct?
Correct.
And that was negative, but for marijuana drug screen, which you have the medical card, correct?
Yes, correct.
And again, you took the test in December 10, 24, correct?
Yes, ma'am. Correct.
Okay, and this is our exhibit number 3. And that was after the hearing with Judge Lee, correct?
Correct.
And that was as requested by Mr. Tomlin, correct?
Correct.
Now, did you have any requests from Mr. Tomlin since December of 2024 to take any kind of tests?
No, ma'am.
Now, our exhibit number 4, that is that true copy of your medical card?
Yes, ma'am.
And it's still valid as of today?
It is still valid.
on test results in December 10, 2024, you also tested positive for amphetamines, correct?
Correct.
And then again for marijuana. True?
Yes, true.
Okay. You submitted as exhibit number 5 your prescription where you take how you pronounce it, Vivacin,
Vyvanse?
Vyvanse, and that that medicine contains the amphetamines, correct?
Correct.
Is that the reason you tested positive for amphetamines in December of 2024?
Yes, ma'am. I have an active prescription for it.
And you have this kind of prescription as of today?
Yes, ma'am.
Buckle up, guys, because the mother's side comes in strong with a redemption narrative that's clearly designed to shift perception. Her attorney paints a picture of transformation, years of sobriety, completed counseling, and a genuine desire to reconnect with her kids. It's a calculated move to rebuild credibility and show growth. The emphasis on consistency and effort is meant to convince the court that she's no longer the person she once was. This is where sympathy starts to build, but whether it's enough remains the big question.
Now, Mr. Tomlin is asking that you be subjected to 10 panel drug testing. And are you okay with that?
Yes, ma'am.
You're ready to take it today or any day in the future?
Any day.
And you're requesting the court that if the court choose to order drug testing, then Mr. Tomlin is responsible for payment of that test?
Yes, ma'am.
Now, our exhibit number 6 is temporary orders that were issued as a result of the hearing on December 5th, 2024, correct?
Correct.
And Judge Lee ordered that you will have electronic access to the children on Tuesday, Thursdays, and Sundays from 6 to 7, electronic access for Christmas, and other possession, correct?
Correct.
Now, from the time of the hearing throughout the 2025, did you have this electronic access to your children?
I did not have access up until December of 2025 after we went through mediation. That Christmas, we started our visitation.
Okay, and that was the reason that Mr. Tomlin insisted that your possession, electronic access will be subjected to reunification counseling, correct?
Correct.
And you tried to contact kids therapist at that time, correct?
Correct.
Were you successful in
I was not. No, I was not.
Did they even return your call at any time?
No. No, ma'am.
Okay, did you try to find your own reunification therapist?
I did. The issue with that being is that the reunification therapists require in-person reunification therapy, to which at this time I'm living in Florida, so it was not possible.
Okay, and after even at that time, Judge Lee ordered that you have in-person visits once a month after the 20 periods of electronic access, correct?
Yes, ma'am. Correct.
Now, because we didn't, you were not able to have electronic access to your children in December 11, 25, we went to mediation, correct?
Correct.
And we reached an agreement, whereas we pretty much mirrored Judge Lee's orders, but eliminated the requirement that there's number 4 on page 3, that requirement of reunification counselor, correct?
Correct.
And then at that point, we all sign on mediated temporary orders, whereas we change that we eliminated this provision and you resume access to your children, correct?
Correct.
Now, do you believe how the visitor how the visitor going? Could you tell the court?
They're going good. Obviously, it's hard to do something over Zoom. It is a little awkward in the beginning, but I feel as though time has gone on, the kids seem very engaged. They're not at the skate park like they were in the very beginning of everything. You know, I feel like as time goes on, the more we get to know each other, things have gotten better. I know that the kids are anxious for the in-person visit as well as myself.
Okay.
Anxious as in a good way. We're excited.
Counsel, that was your last question. You ran out of time.
Thank you, Anna.
You're welcome. Cross?
Briefly, Your Honor. Ms. Jackman, you understand that you've been absent for the vast majority of these children's lives, correct?
I do.
And that you only filed, whatever happened in 2020, you only filed to actually change those orders in 2024.
All right, guys, just as sympathy begins to form, the father's side steps in and completely flips the narrative. Instead of redemption, they highlight abandonment, 8 long years of absence and emotional damage left behind. The mention of missed visits and broken promises hits hard, especially when it involves children already dealing with that loss. This isn't just a legal argument anymore. It's emotional ammunition. The father's stance is clear. Stability has already been rebuilt without her, and reopening that door could do more harm than good.
I do.
Okay. And you would do anything for these kids, right?
I'm doing everything I can possibly at this time, yes. Granted,
Now-
I'm living here and they're there.
Now, your counselor or your attorney showed you that the orders put in place by Judge Lee required reunification counseling, correct?
Correct.
And there was some complaint that you weren't able to have electronic access before. Judge, may I share screen?
Yes.
All right. Looking at this paragraph, it says it is ordered that Brittany Jackman shall be able to contact the counselor. I'm sorry. Yeah. Counselor for the children for a proper reintroduction. You see that for a proper reintroduction?
Correct.
Now, ma'am, that would make sense that that happened before any electronic access or in-person access, correct?
Correct.
And you were not able to get that done.
No, I was not able to find a reunification therapist that would do it.
You were not willing to come to Texas for reunification therapy, right? Yes or no,
That's-
ma'am?
I'm unable at this time.
Okay. And ma'am, you have provided us with your pay stub that we have marked as Exhibit F8. Let me publish that, Your Honor.
Yes.
Is that a true and accurate copy of your pay stub, ma'am?
It is.
Okay, thank you. And Your Honor, for your purposes, we have already stipulated and admitted F9, which is the child support calculation. It's a little different than Judge Lee's. But
Okay.
we have submitted that.
Thank you.
No further questions of this witness, Your Honor.
All right. You may call your next witness.
Thank you, Your Honor. Your Honor, I call Mark Tomlin.
All right.
Sir, when that default decree was entered in 2017 in Tarrant County, you were appointed the sole managing conservator, correct?
Yes, sir, correct.
And Brittany Jackman had no access at that time.
That is also correct.
In fact, she had already moved to Florida before that default was entered.
From what I understand.
Yeah. And she did not attempt to contact the kids for approximately 8 years, correct?
Correct. Yes, sir.
So during that time, you had to deal with, as these kids grow older and they're seeing their friends with complete families, that fallout, right?
That is correct. Yes, sir.
Had to include these kids or put these kids in counseling for those feelings that they were dealing with.
That is also correct. Yes, sir.
And meanwhile, you tried to go ahead and create a life for you and the kids moving forward.
Yeah, I've done so.
Your Honor, at this time I publish F2.
Okay.
Sir, this is a picture of the family that you have made and the life that you have made with your kids, right?
I can't see any pictures, but yes,
I forgot to hit the share.
no problem.
There it is.
Yes, sir.
And we have a couple of them so that the court can see you and your kids and how your life is now.
Yes, sir. Correct.
Okay.
Okay.
While Brittany was gone until 2024, did she pay you any child support to help support these kids?
No, sir. No.
And in fact, in 2024, she owed almost $30,000, right?
That is correct. Yes, sir.
You had to have me file an enforcement action, which ended in an enforcement order, right?
Yes, sir. Also correct.
Meanwhile, in 2024, she files a petition asking to jump from nothing to a standard possession order, right?
That is correct. Yes, sir.
So at that point, you felt you needed to hire an attorney.
No, definitely.
Okay. And at that temporary orders hearing for visitation, possession, and access, Judge Lee indicated, and the order says that Brittany is supposed to contact the counselors for the children for a proper reintroduction, right?
Yes, sir. Correct.
Now, you heard her testimony. She couldn't find any reunification counselors that would do this process remotely, right?
Yes, sir.
But at that hearing, did Brittany Jackman state that she'd be willing to do anything, even come to Texas to see these kids?
She did. Yes, she said.
And at least as far as you're aware, did she make any efforts to come to Texas for reunification counseling?
No, sir. Not whatsoever.
And it was your understanding that that needed to take place before electronic access and before in-person visitation?
That is what I understood.
Okay. So at mediation, you did end up agreeing to knock out that reunification because of the logistics, time, and cost, right?
That is correct. Yes, sir.
And you wanted to give her a chance to see if she could become involved in these children's lives.
Yes, sir. Correct.
Now, leading up to these electronic access points, describe the demeanor of the children. Were they anxious?
Stressed out, anxious. Yeah. Yes.
Okay, not comfortable.
Not comfortable necessarily. No, sir. No, sir.
Did you work with them to try to make it more comfortable?
Yeah, definitely.
Including making sure that there were other things to do in case this now 10 and 11-year-old, so still very young, couldn't focus or didn't want to or needed some sort of break?
They asked me specifically, in fact.
Okay. In terms of these electronic accesses, were they consistently late or missed?
Yes, just about every time.
And according to
Not
Judge
missed.
Lee, they were going to be 3 times a week, correct?
That is correct. Yes, sir.
That's a lot for a 10 and 11-year-old, right?
Yeah, it's been a while.
Okay. And then in fact, did Brittany promise these children that she would be visiting them after she completed her 20 sessions outlined on March 15th?
Yeah, she had told them a couple of times.
Now, did she actually show up on March 15th?
March 15th came and went, and we heard nothing about it ever again.
Had you tried to prepare these kids and make sure they were ready for mom to come in on March 15th?
As best as I could. Yes, sir.
Buckle up, guys, because now we hear from a neutral third party, and this is where things get interesting. The visitation supervisor provides a grounded perspective, confirming that the mother has been showing up and actively engaging with her kids. Despite distractions during visits, the overall tone is positive, and there are no major concerns raised. This testimony quietly strengthens the mother's case with real observations instead of claims. It's not dramatic, but it's powerful because it introduces credibility backed by consistent interaction.
Now, when your mom promised you something and then doesn't show up, it creates a sense of abandonment, right?
Yeah, it definitely, they had a lot of feelings about it for sure.
And in fact, the kids share those with you.
Yeah, we share it.
That sort of fallout is what you were trying to avoid with setting up this process through the mediated settlement agreement, right?
That's been my concern.
But if Ms. Jackman can't provide stability in terms of what to anticipate and what to expect, That's not good for your kids, right?
No, no,
It doesn't create stability. It doesn't create security for them.
very good.
Are you asking moving forward in their best interest that visitation not be court ordered due to this
Yes, correct.
and to the 8 years absence of Ms. Jackman?
Also correct. Yes, sir.
If there was to be visitation, you're asking that it be by agreement between you and Ms. Jackman.
Yes, I did use it. Yes, sir.
And with electronic communication, you're asking that that not be court ordered for 3 days a week at a specific time, right?
Yeah, I believe that'd be good.
Okay. And well, not last, but there is a geographic restriction in that prior order, right? Tarrant
Yes,
County?
also that.
You're asking that be lifted since mom lives in Florida, has not exercised possession of the kids, and it serves no purpose, really.
Yes, sir. We've been looking for a house, and it kind of limits us. Very much so.
Now, you hired me to represent you in both of these cases, right?
Yes, sir. Correct.
And Your Honor, opposing counsel and I have stipulated and agreed to pre-admit F12 and F13, which would be the client fee agreement and the invoices or the time slip listing for this case.
Okay, thank you.
Now, sir, during this process, even after 2024 and that enforcement order, you have received no child support.
Still, yeah, limit for sure.
Now, just to be fair, Ms. Jackman has provided proof that she has made payments to the OAG, but for some reason it's locked up within the mechanisms of the OAG.
From what I understand, I guess so.
Okay. So you've incurred this essentially out of pocket with no help even from child support.
Very correct.
Are you asking that those attorney's fees be reimbursed to you?
Yes, definitely.
And the total amount for this case, let's go down here, because of having to deal with the initial temporary orders hearing, doing discovery, as well as the mediation, and then temporary orders after that being drafted, and following up with supervisors, you, as well as other things, you've incurred a total of $35,439, right?
As of now, as of today, yes, sir.
Okay. And then you have your requested relief. Let me share that on screen, Your Honor.
You may.
You're asking that the court deny the requested relief of mother and that she be ordered to pay guideline child support based off of the calculation from the OAG's website and her pay stub, correct?
Yes, sir.
You're asking that her possession be denied at this time unless by agreement of the parties.
That's correct.
If it is to be granted at all, you're asking that it be dependent on passing us another 10-panel nail test, right?
Yes, sir.
Just to confirm that she's not using any other drugs than the marijuana, for which she has a license for in Florida, even though it's not legal in Texas, and the prescription medication she has.
Yes, sir. Correct.
You're asking that that geographic restriction be lifted, correct?
That's correct. Yes, sir.
Okay. You're asking in number 7 that if she does get access, that she not remove the children beyond Dallas or Tarrant County, right?
That is correct also. Yes, sir.
And then you're asking that she pay reasonable attorney's fees?
Yes, sir.
And it sounds like there's no request to change any of the other rights and duties from that default order. Is that your understanding?
That is. Yes, sir.
Okay. No further questions of this witness, Your Honor.
Thank you. Not that it's necessary, but counsel, did you want to make a closing statement? You have 1 minute and 10 seconds left.
No, Your Honor. Thank you.
Okay. The court has a couple of questions. Ma'am, you said you're unable to come to Texas. What is the reason for that exactly?
Unable to come, it's not that. I can come and do my visitation, my in-person, but the requirements for unification are 3 times a week with each visit. So I mean, I run a store here, which that's fine. I don't have an issue of moving. It's just I have my career here, so I would have to make a transition over. So it's not that there is I don't want to. but also I'm trying to build this relationship with both my children. To jump straight forward into moving to Texas as well as doing that, I feel like that's just going to be a lot on one single person. So I'm trying to build my relationship with them, but it's not that I won't come to Texas.
Okay, I understand. And maybe I don't know if you've thought about this, but since you're here, I'm just going to ask you, okay? When, if at all, like how soon would you even be able to relocate to Texas if you were to start working on that?
Well, my partner and I have already began looking at homes out there. So it's a process. It's in the works,
Okay.
but that's where we want to be, is Texas.
When was the last time you sought out a reunification therapist?
Pretty much the whole first half of 2025, once I was granted the access, or was it 2024? Yeah, no, 2025. Everyone that I contacted it's an in-person thing. There's activities that they want both the child and the parent to participate in that can't be done via Zoom.
Okay. If you were to take a drug test, would it be done at that same place, the Quest Diagnostics?
If it's urine, it would be Quest Diagnostics. If it's the nail test, it would be done at that Any Lab Test Now, I think.
Mm-hmm.
I mean, they both can be done there, I guess.
All right. How soon can you get the test done?
Which one are we requiring? Because I cannot afford to take the nail test at this time.
He requested nail.
That's almost $600.
Well, here's the deal. What I typically do is the person who requests it has to pay for it. And if it comes back positive, then that person has to reimburse.
I mean, that's fine. If he pays for it, I can do it today. I just have a doctor's appointment at 2:20. I can go right there afterwards.
Okay. And I will give you time. I understand that. I would need a form from them to be able to send you over there. Councils, would you all be able to get that for me? A form for the nail test? I don't know. I haven't looked it up yet to see if they have one online or not. So we can get that done.
Your Honor, I believe what we did before was Ms. Jackman submitted to Any Lab Test Now in Florida, Pensacola, Florida, and directed that the results be sent to the attorneys of record.
Oh, okay. Well, if they'll do it like that, that's fine.
You would have to pay for it before they take the test.
Mm-hmm. So that would be the issue. Last time you paid for it, right?
Yes, ma'am.
Okay, so I think we probably need to contact them to see how they would want that to take place. Considering that the person paying is not taking the test, they're probably going to want something in writing. So see what, if anything, they would need from me. So I can do that today and I can send her over there tomorrow. Do you have anything planned besides work, Miss Jackman?
I work 9 to 9 tomorrow, Friday, and Saturday. I get off at 6, but I have, and can I look at my calendar real quick to let you know my lunch? Okay, I have a lunch tomorrow at...
All right, guys, the tension sharpens as cross-examination begins, and this is where every detail gets scrutinized. The father's attorney tries to poke holes in the narrative, pointing out missed and late visits to question reliability. It's a strategic attempt to reintroduce doubt right after positive testimony. Even small inconsistencies are used to suggest that the mother might not be fully dependable yet. This moment reminds you how quickly momentum can shift in court. One strong point can be challenged just as fast as it's established.
Sorry.
You're okay.
My lunch is...
It's at 1:20, and so I have an hour. They're usually very fast. When I went there, I do have gel polish on my toes, so I have to remove the gel polish so I can do that tonight, I guess. But yeah, they're pretty quick with the test. But I
Okay,
can get that done tomorrow during my lunch.
all right. So should I say 1 o'clock exactly, or should I say like 12:50?
1 o'clock exactly would work. I have a client at 1, but she's a friend of mine. I can just move her. I'll text her.
Okay. So that's what we'll do. If the attorneys could find out what, if anything, that I would need to send over to the facility to ensure that dad makes the payment and mom takes the test, that would be great. And mom, you're going to take the test tomorrow at 1 p.m.
Yes, ma'am.
And I'll just tell you, don't cut your nails,
Yeah.
do anything to modify your nails or anything like that. Just to make sure there's no issue with the test, okay?
Yes, ma'am.
And I have to ask, is there anything other than the prescription for, is it Vyvanse?
Yes, ma'am.
Is there anything other than amphetamines and marijuana that's going to show up in your system?
No, ma'am.
All right. Let me see, is there anything else? And the marijuana, this is recreational use?
No, it's medicinal. It's prescribed by a doctor.
Okay. What is the prescription for?
For anxiety. And I have the updated prescription information. If you need that as well, I can have it submitted to Ms. Hiscall, and she will get it sent over to you.
Okay. Thank you.
Yeah.
Mr. Tomlin, you're asking for a lift of the geographic restriction?
Yes, ma'am.
Are you trying to move?
I've been trying to buy a house, and it's kind of limited my ability to do so. Yes, ma'am.
Okay, so you're trying to get a house outside of Dallas or Tarrant?
That's correct. Yeah. Yes, ma'am.
Got it.
Excuse me.
Okay. I think that's all the questions that I have for now. I'm going to take this under advisement, and it'll be pending the drug test results. I did have one more question now that I think about it. Blaze just turned 12, right?
He just turned
Yes.
12. Yes, ma'am.
Okay. I would like to speak with the children.
Yeah, definitely.
Let me look at my docket. Well, spring break has already passed for them.
Yeah.
They have STAR testing coming up.
Yeah, they have a whole lot coming up. It's like the end of the year. Yes, ma'am.
Yeah,
Definitely.
April gets pretty hectic.
Yeah.
Do they have any testing in May?
I'd have to look into that. I'm not too sure when their testing is exactly, but I'll have to look into that definitely.
Okay. Attorney Harding, would you be able to give me an email? Sent my coordinator, of course, put everyone on there. I just need to know when their testing days are and what time they get out of school, because I can interview them at a time that they're out of school. And the interview, it usually doesn't take longer than 30 minutes, but of course it depends on how long your kid want to talk to me. So it could be 45 minutes, it could be an hour. I'm pretty fun.
Kids talk. Yeah. Be ready.
Okay, I'm pretty fun. So they
Yeah,
might want to
good,
talk
good.
a little longer.
They'll like it then.
Yes, so let's do that. In the meantime, waiting on the drug test as well as my ruling, I would like to speak with the children.
Yeah, definitely.
Okay, is
Yes,
there
ma'am.
anything further for the record?
No, Your Honor.
No, Your Honor.
Okay, all right, well, thank you all.
Yeah, thank you.
Thank you.
You're
Thank you.
welcome. Have a good day.
Yes, ma'am. You do the same.
Thank you.
Bye-bye.
Buckle up, guys, because this final stretch dives deep into the mother's past, and nothing is held back. From jail time and fraud charges to years of separation from her children, every detail is laid out in full view. But alongside that, we also see her efforts to rebuild, sobriety, therapy, and repeated attempts to reconnect despite obstacles. It's a complex mix of accountability and redemption, where the court has to weigh who she was against who she is now. This is the heart of the case, where judgment truly matters.